Welcome to Safety Spectrum, your environmental health and safety connection. This program is a presentation of the Michigan Safety Conference. For almost a century, the annual conference has provided credible educational opportunities and valuable support to the safety and health practitioner by offering 120 instructional programs along with exhibits highlighting the latest in safety equipment, instrumentation, and demonstrations. To learn more about the conference, please find us at safetyconference.org. Spectrum, I'm your host, Sheila Ide. This program is sponsored by the Michigan Safety Conference, and our topic today is marijuana and employment law. Employers face many challenges in recruiting and maintaining a competent workforce. The changes in laws surrounding marijuana have added to that challenge, which our guests today will discuss. Our guests today are Dan Deacon and hopefully Anthony Casaletta from the law firm of Conn, Maciel, Carey, LLP. Dan and Anthony also spoke at our recent 2025 Michigan Safety Conference. Mr. Deacon is a partner in the Washington, D.C. office, working in both the labor and employment and OSHA practice groups. He advises and represents employers on a wide range of employment-related issues, including wage and hour disputes, claims of discrimination and harassment, compliance with Americans with Disabilities Act, the Affordable Health Care Act, and family medical leave. He helps employers develop and implement effective workplace policies and safety and health programs. Dan also represents and advises employers during inspections and investigations conducted by federal OSHA. Since I'm hoping our second speaker from Michigan will be on, I'm going to go ahead and introduce him. Mr. Casaletta is a senior counsel working in the Detroit area, where he provides a full range of workplace safety and health law services to employers in Michigan and around the country. Anthony counsels and defends employers across a diverse range of industries and a variety of workplace health and safety matters involving federal OSHA and state OSHA plans, particularly Michigan OSHA. Prior to entering private practice, Anthony spent 18 years with Michigan OSHA. Yay! His final position was health supervisor for MyOSHA's Construction Safety and Health Division. He supports clients in all aspects of enforcement actions involving OSHA agencies. Well, thank you for joining me today, Dan, on Safety Spectrum.
Likewise, thank you for having me.
So did I miss anything about talking about your firm and your special?
No, that was a great intro for myself and Tony. Our firm is a nationwide practice focusing on labor and employment issues and workplace safety and health, and mine safety and health as well. So three kind of niche practice areas that we specialize in, but we have offices in DC, Columbus, Detroit, Chicago, and Los Angeles and San Francisco. So we cover basically all 50 states, and really well versed in the topic that we're talking about today, marijuana and employment law.
Yeah, that seems to be a big issue. It also seems like a lot of changes are coming for the administration, so our roles may be changing. So
Right.
how is the legalization of marijuana impacting employment laws?
Yeah, so there's been kind of a whole host of issues that have come up with the legalization of marijuana, either on the medicinal side or for recreational purposes, right? And from a federal law perspective, and we're talking about marijuana, it is still considered a controlled substance under the Controlled Substances Act and illegal. However, we have a patchwork of state laws now. Some say you can use medicinal marijuana, and that's been legalized, but not for recreational use. Some states have legalized both medicinal and recreational use, and there's a small subset of states that still prohibit marijuana, both for a medicinal purpose or for recreational use. So there's this broad array of different laws, a patchwork of state laws that really make it challenging for employers to create one consistent drug testing policy or drug-free workplace policy in those circumstances, because even those laws that are out there for medicinal use or recreational use, those are different in and of themselves as well. So it really is challenging to create one consistent drug testing policy, drug-free workplace policy for large employers that operate perhaps in 50 states or a large subset of the country.
Yeah, I was going to say, I'm going to reemphasize that if you have operations over several states, you're having to look at different rules for everything. I don't know. States having their own rules is always such a good idea on some of these things. So what are some of the challenges employers are facing in testing programs? Like I say, we would all love to see one solution to everything, but that's not possible. So,
Mhm.
so what about
Yeah,
testing programs?
yeah. For the various different states that are out there, there's different laws about what types of tests that you can do, whether that's pre-employment, random, post-incident, pre-employment. Some states prohibit testing for marijuana in pre-employment circumstances, but you can test for it in random or reasonable suspicion. And some states allow you to test for marijuana across the board over an array of different types of tests that you may implement, right? So that is the challenge there is you really need to dive into each specific state law that you operate in to look at, what the drug testing laws are, if there are any, but also into the specific laws on recreational use or medicinal use. And you need to craft your policies according to those specific laws. So it's not easy, and it's definitely a challenge for employers that operate in multiple states. But that's the reality we live in right now. This isn't the only law that is kind of a patchwork of state laws where the federal government doesn't necessarily speak to that issue, but it is one of the big ones that employers certainly face.
Yeah, I created a program for one of the companies I worked for many moons ago, and I'm sure things have changed since then. But I mean, do people actually do hair testing and things like that? I mean, are some states allowing that? I mean, how far do you go?
Yeah. There's some states that permit that. Some states where it's urine sample only, breathalyzers. There's a whole different type of array of laws on what type of specimens you can collect, how that specimen is handled, how test results are handled with confidentiality provisions. So all those things come into play and what you really need to look at when developing your drug-free workplace program and your drug testing policies.
So it could be different things for different reasons. I know DOT has specific requirements for testing.
Yeah. Yeah.
Mhm.
If you are a DOT driver, a CDL driver, your drug testing program is governed by the federal government. That's one of the laws that the federal government has in place that requires drivers to perform certain types of drug tests, what type of drug screening panel they're subject to. And anyone that falls under the realm of the DOT jurisdiction, you are certainly subject to those requirements. But outside of that context, the federal government really doesn't have any drug testing laws that speak broadly to what type of tests are permissible, what type of specimens you can collect, what type of tests you can conduct, all those things that you see in state laws.
And I think what complicates it as well is we've never really determined what level of marijuana use impacts your behavior or, like alcohol, that's pretty well documented, but we haven't really reached that kind of information on the marijuana end of it. So how do we know somebody's under the influence? So that's got to be a challenge as well.
Yeah. I mean, testing for present impairment, right, is tough when we're talking about marijuana, because there isn't a test that can identify that. I mean, there's certain state laws now in, the vehicle safety codes, right, where if they have a certain level of THC, that's deemed present impairment, but we don't have that in the employment law context. So that's an area that is a developing area of the law, I guess that you can say, and something that we would be closely watching over the next several years as technology advances. And certainly there's companies out there now that are trying to get a test that can identify that, right? And
Experiment.
whoever does is probably going to be very, very rich, right? It's something that a lot of employers deal with, and certainly state and local law enforcement agencies would be interested in that as well. So yeah, that is something that is tough, but that's why whenever we're talking about marijuana, say there's a post-incident test that you're considering, we always recommend doing a reasonable suspicion analysis in conjunction with that potential post-incident test, right? Something happens in the workplace. Let's have a manager talk to that employee, see if there's any signs of present impairment, odor on their breath, we're talking alcohol, glazed eyes, all the kinds of sensory cues that may indicate someone is impaired. right?
Yeah.
What's the behavior like before the incident, leading up to it? How are they conversing with you? Their demeanor, their behavior, is anything abnormal? So anytime something like that happens, and you're considering doing a test, certainly in the post-incident context, we recommend always doing a reasonable suspicion analysis, because if you get a positive test back and it's just for marijuana, then you also, if you have done the reasonable suspicion analysis and there's something awry there, you have two different justifications for, one, conducting that test, but also perhaps for taking adverse action on the back end.
Yeah, you're kind of sliding into something I was going to ask about how you would document behavior, but what if you find out they're positive for something else?
Yeah, so other
When
drugs.
you talk to companies, when you help them put their programs together, do you actually discuss what they should do or how they should, if they should address all drugs that could be?
Yeah, so this is, I mean, there's several different buckets that you can kind of place drugs into, right? And I guess marijuana in particular is one that is set to the side by itself because of the different patchwork of state laws that are out there and the legalization of marijuana for medicinal and recreational purposes. But if there's other illegal substances that are illegal under both federal and state law, we're talking, things like cocaine, PCP, those types of things. If you have a zero tolerance policy and one of those shows up, um, then you can certainly take adverse action on that. And there's certain state laws that, even where recreational and medicinal use is legalized, where you can still enforce a zero tolerance policy. One of those is Michigan, right? There is no
Right.
employment law protections for marijuana, even though it is legalized both for recreational and medicinal use purposes. Now, there's other drugs, right, where, say, they're legally prescribed medications for someone that has a condition. Maybe they're injured on the job and they've been prescribed opiates. That's another separate bucket of drugs that may pop up on a drug screen panel
Yeah.
following a test. In those situations, that raises some additional employment law concerns with the Americans with Disabilities Act. Is that person, and you'd have to go through the entire analysis, right? Is that person considered a qualified individual with a disability? Do we need to engage in the interactive process and consider a reasonable accommodation of some sort? So there's a lot of different things that can pop up when we're talking about drugs in the workplace. So I like to think of kind of those separate buckets when we're talking about marijuana, other
Gotcha.
illegal drugs, and legally prescribed drugs that may pop up on a drug screen.
I want to take a second here to welcome Tony Casaletta, who just joined us. He's got a Michigan base here. We just started talking about some of the issues. Anything you want to add or just say hello at this point?
No, Sheila, thank you. I apologize for being late. Dan, how are you? Good to see you. Thanks again for the invite. Um, yeah, I'm an attorney with Conn, Maciel, Carey. I'm based here in Michigan. I'm former Michigan OSHA compliance officer for 18 years and supervisor. Been an attorney for about 6 years, working with Conn, Maciel going on 3 years. So excited to be here. I was excited to present this interesting and fascinating um, presentation with Dan at the safety conference earlier last month. So I didn't mean to throw off the flow here with
That's
everybody,
fine.
but I'm
Just
glad
want
to be here with
people to know
everybody.
you were
So
here.
thank, yeah,
This is going to be out in left field, but police have, say they stop one of your drivers, a DOT driver, safety sensitive, and they smell marijuana or they have reason to, I mean, there would be a whole different set of rules there, wouldn't? I mean, where employee may not be in trouble because of the accommodation, but then the police might, I mean, like I say, it's out of left field. What do you think of that? Is that ever?
Yeah, I mean, if there's something that is involved with law enforcement, certainly they're going to do what their job entails, right? And if there is a drug test that is conducted, whether field sobriety, all that kind of things that might go into their assessment, they certainly can do that from the employer's perspective, right? If there is any type of drugs that are found following a police stop, something like that, that impacts their responsibilities under the DOT regs and whether that person can even continue driving, right? So
Right.
those results would be considered and factored into their employment. And the
Yeah.
DOT regs are very, I don't want to say strict, but they're very well established, and the implications of violating those policies are very, very clear, for lack of a better word.
Well, I'm
There's
going to move into ADA. I think at this point, I had motor carrier drivers where I worked, and
Mhm.
we had the medical testing, and I had one who always brought an attorney to meetings. He would refuse to go through the company doctor for his testing, and he would bring I'm not getting an attorney to the meetings, and said that we couldn't because it was an ADA issue. So,
Mm.
can you explain how ADA issues are involved in all this?
Yeah, there's a host of different ADA issues that can come up, right? I touched on one of them where, someone is legally prescribed medication for some type of condition that may show up on a drug screen and may impact their ability to do their job. But if that person is considered a qualified individual with a disability as defined under the ADA, the Americans with Disabilities Act, that triggers additional responsibilities for the employer to engage in the interactive process, perhaps provide a reasonable accommodation and go through all those steps under the ADA. Now, when there's safety sensitive positions, there's certain exceptions for that, but that doesn't mean you can just necessarily fire someone either. A reasonable accommodation could be, unpaid leave or transfer to a different job. There's a whole host of considerations under that ADA analysis that you have to go through. And on the other side of things, right, there's the disability accommodations that are spelled out in some state laws. For example, medical marijuana laws, not necessarily in Michigan, but certainly in other states. There is affirmative duties to accommodate people that have been legally prescribed marijuana for medicinal purposes. So like I said, this all goes back to make sure that you're checking your state law as well, to see if there is any affirmative duty to accommodate individuals.
So
Those
you're
are
saying there's not one easy way to do this, not one policy, huh?
no, unfortunately not.
That's what we all want, you know that?
Yeah, that's what certainly large employers want: consistency amongst their policies. That's easier to track, to manage, to implement. But this is one area where that's really not feasible in many cases.
So what do you consider employees should be thinking about from a legal standpoint that we haven't covered? What are some of the issues
That employees or employers
that,
should be
that the
thinking.
employer should consider? What kind of things could they get in trouble with, like privacy issues or?
Yeah, there's certain things that you definitely need to take a close look at when developing your drug testing policy, right? First, the state law considerations, but even if there's no state drug testing laws, some other things that you want to look at, like privacy laws and whether, a certain type of sampling would be considered an invasion of privacy, right? Making someone give a sample, a urine sample, and you watching them. Like that's a classic example where courts have deemed that to be an invasion of privacy in many circumstances. But some other things that come up are state law off-duty conduct laws.
Right.
Um, the off-duty conduct laws aren't necessarily something that you find in the drug testing section of the code, right? Or embedded in the marijuana code, either the recreational or medicinal use. But there's many laws out there in states where it's essentially you cannot take adverse action or penalize someone for lawful off-duty conduct, right?
Yeah, I
And
heard that a lot in the meetings when I was training people. You can't
yeah,
tell me what
yeah,
I do when I'm not working, right?
yeah. And if there is a state law that says recreational use is legal, and there is an off-duty conduct law that prohibits you from taking adverse action against someone for engaging in lawful protected activity, right? I shouldn't characterize it as protected activity, but lawful off-duty conduct. Those laws can impact the decisions you make in employment circumstances, right?
Absolutely.
Yeah, yeah.
Well, I'm
So
going to flip it over to Tony a little bit. Employers in several states have different issues, but how does the legalization of marijuana for both medicinal and recreational impact Michigan employers?
You know what? That's actually a good question for Dan. Sheila, that's more of Dan's issue. I can definitely answer some of the questions with regards to, how it relates to OSHA related matters, but as far as the legalization for, how, what are some of the issues, I'll let Dan kind of chime in on that one.
Well, what is OSHA's stance? Since you bring that up, what is OSHA's stance about this?
Sure. As far as the limitations, what we're going to get into is, some of the post-injury testing. And, OSHA's preamble to the final rule does limit post-incident drug testing to some extent. Employers don't necessarily want to have a written policy that requires a blanket post-incident drug testing after any and all incidents. And the reason for that too is just you go back to what the main intention of OSHA's injury and illness record keeping requirements were, and those are to assist employers in tracking and identifying work-related injuries and illnesses for the purposes of helping them to understand where are the gaps in our programs, what needs to be done, where do we need to beef up things, and encouraging and having employees report when they're injured helps to identify, oh, hey, we need to beef up this area over here. Maybe it's, an issue with, machine guarding or whatever, or hazard communication training. If we're understanding what's causing the injuries or illnesses or where they're occurring, and those are being reported to us, we can kind of buttress up put a buttress for those specific areas. But when you're having drug testing after every single injury or every single incident, what it could do is it could put a chilling effect on the reporting of these injuries and illnesses. And that's really what we don't want to see. And that's what OSHA doesn't want to see. So having an employer, the employer's doing by implementing mandatory drug testing after every single incident is going to deter employees from reporting injuries and illnesses. And that's really what we don't want to see here. So employers can continue, performing post-incident tests to evaluate the root cause of an incident, but there needs to be an element of reasonableness when they're putting that into place and when they're trying to, determine if and when they want to do the the drug testing. For example, Dan and I have talked about this before. If someone reports a bee sting, in those circumstances, it's not necessarily reasonable to test while it could be a reportable incident. But on the other hand, say you have an incident involving a crane, someone is injured, and there's multiple individuals that are involved. You have an operator, you have a rigger, you have the signalman, you have a bystander. Something went wrong there. It would be reasonable to conduct a post-incident test in those circumstances. But if you're going to be doing those post-incident testing, make sure you're testing all the individuals that may have caused or contributed to the accident, not just the injured employee, because there's so many different factors that could be involved in there.
Do you want to weigh in on what we're talking about there, Dan, as far as states that have both medicinal and recreational allowances?
yeah, as far as
The challenges it gives to the employer.
challenges, yeah. So it's tough. Well, let's talk first just about Michigan. So in Michigan, you have a recreational use law and a recreational, or did I get those mixed up? Medicinal and recreational use laws, right? So the challenges that employers face, right, is we know based on data that a large subset of folks in Michigan are purchasing and using medicinal or recreational marijuana. That's just a fact. It's one of the states with the highest number of sales per capita. So the odds of folks in your workplace using it are quite high. I think it was something, I don't have the data in front of me, but something along the lines of like 14% of all the population in Michigan is using marijuana. So when you put that into context, that's pretty large. If you extrapolate that to your workplace, that's a large number of people probably that we're talking about, right? So how do you balance that with some of the considerations that are out there? Like, do you implement a zero tolerance policy? In Michigan, you certainly can. The medicinal use law and the recreational use law do not have any employment protections. So you can enforce a zero tolerance policy and take adverse action against someone for using marijuana. Now, does that jeopardize you from maintaining a strong and competent workforce? Is it going to be challenging for you to attract people to your business or maintain, high functioning, really good employees? That's one consideration that a lot of folks are considering, right? And do we loosen the reins on marijuana in our drug testing policy? So that's a challenge for a lot of employers and something that we've seen a lot of clients battle with and think about and make some changes as to when and how we perform drug tests, right?
So, I mean, we pretty much in Michigan, don't we have an at-will employment situation anyway? You can be let go for any
Yeah,
reason or no reason, right?
yeah, most unless there's
You-
some type
So
of
you wouldn't
employment.
necessarily have to say it was related to drugs. I suppose it'd be getting into the whole privacy issue or whatever, but
Yeah, I mean, ideally you want to have some cause for terminating someone if it's drug testing related. But you're right, you can terminate someone for any reason if they're an at-will employee. There's a lot of considerations that go into terminating someone, right? Usually you're not just terminating someone for the sake of just
usually a pattern. There's usually a
yeah,
pattern.
there's some type of behavior issue, performance issue, maybe it's drug related, a whole host of issues, but there's other things you want to consider there too to protect the company, right? Whether it's age, any of the protected categories in Title VII or under state law, age, race, sex, all those types of protected
Well, we
categories.
talked about privacy a little bit and different things that we might inadvertently do. I know when I was doing the program, I had to pull out so many people for testing, drug testing. So everybody knew why they were getting called out. And if somebody doesn't show up, I mean, it's kind of hard to, if they don't come back to work, then you kind of, everybody's going to know. I don't know how you protect yourself against that. I mean, people just, they talk.
Yeah, yeah, and in Michigan, certainly employees that are working in a workplace with a zero tolerance policy, but maybe have a medicinal card or use it recreationally, they're running a risk, right?
Yeah.
And leaving it into the employer's hands on what type of action is going to be taking. But if they're violating the policy, the consequences are clear, or at least we hope it's spelled out in your written policy what the consequences are if you violate that, right?
Well, we talked a little bit about post-injury testing. I know Tony brought that up about, not having a blanket policy. So how do you, what would you call reasonable suspicion then? How would you handle if you're not going to test after every incident? I mean, how do you even write the policy up? I mean, how
Yeah,
specific can you get?
yeah, I mean, with regards to reasonable suspicion, and Dan can kind of, chime in on this as well too. I mean, there's a variety of triggers when it comes to reasonable suspicion. But a lot of this is going to be, based on, specific observations from the employer, the supervisor. I mean, an individual comes in and, the supervisor can, just can tell, how are they behaving? Is their speech slurred? Can we smell marijuana on their body? I mean, and things change. I mean, obviously, we've switched from just like smoking marijuana. Now we have edibles. So you're not always going to have those, those distinct odors that certain individuals are going to have when they come in the morning, which, back when I was in college, there was a handful of individuals that come into class and be like, oh, okay, I know what this guy was doing before he showed up today. So, we don't have those distinct situations, those distinct warning signs that you have. But, there's other things too. There's, slurred speech, difficulty conversing and understanding individuals, red or glassy eyes,
But couldn't
hyperactivity,
you be
drowsiness.
sick? Couldn't you be sick actually, or have taken a drug that may be affected? I mean, you can't always assume.
You can't always necessarily assume those things, but what we're talking about is reasonable suspicion. So, I mean, there's, you can having those symptoms in place puts the the supervisor and the company therefore unnoticed, and that we can engage with that employee to kind of start asking the questions, and kind of following up with them as to, hey, I got, are you all right? Something doesn't seem right here. I'll let Dan kind of chime in, but that's just kind of the general basis for, for the reasonable suspicion and what employers can approach.
Yeah. Yeah, it's the drug testing policy, right? We can write the best drug testing policy out there. The implementation part is the most important, right? And it is difficult from an implementation perspective when we're talking about post-incident and reasonable suspicion. And that's why it's important that you are documenting these things and your justification for doing the drug test to begin with, because you want to demonstrate there was reasonable suspicion to conduct this test. Here's why. And maybe the employee is sick, or there's some reason why that behavior outside of drugs was occurring. But in the first instance, is there a reasonable suspicion to conduct that test? If you can justify it, great. And then, of course, if there's a positive test, you have a zero tolerance policy, there's multiple things to back up your decision in the event that you take some type of adverse action, right?
Right.
So
Discipline.
the implementation part is difficult, it challenging, it takes a little bit of time and thought. It's not a black and white kind of yes or no.
It's a training issue. You have to take your
Yeah.
management, your supervisors, and train them on this. I had one incident with alcohol where I got a call about 8 in the morning where someone had showed up at the plant and they fell over and they couldn't get back up, and leaning over him, the supervisor smelled alcohol. So I said, don't do anything, leave him there, call the ambulance. And the doctor at emergency decided to test him. I didn't say anything about what was going,
Mhm.
he blew a .3,
Oh my.
but his tolerance was so high for alcohol that he would come to work and act normal. So I'm sure there's people with drug tolerances as well. So like I say, it's a sticky wicket,
Yeah.
but the trick is not to assume, as far as I was concerned. So what would those, you mentioned some, you've got any other, what other kind of things would constitute reasonable suspicion? Like an accident perhaps, or outside of the physical symptoms of
Yeah, there's physical
manifestation?
signs and certainly behavior and activity leading up to it. You want to question other witnesses, other employees or coworkers, perhaps like, hey, how is this employee interacting with you throughout the day? What was their work performance like? All those kinds of behavioral cues that may be off as well. So talking to other people, certainly the kind of physical and objective signs and symptoms, talking to the individual directly, and having a supervisor, most oftentimes two, someone there to kind of
A
confirm
witness,
you're
maybe.
seeing, you have
Yeah.
a witness to validate that. That goes a long way as well and is important. If you have two people that are kind of verifying, yeah, this something's off here. Here's all the physical signs we're seeing. Here's what we've collected from other witnesses. Behavior was off, work performance was slow and different, abnormal, all those kinds of things. As long as they're documented, we typically suggest using some type of checklist to document the reasonable suspicion analysis. And that's really helpful moving forward.
I think Tony alluded to it. It also could be the incident itself of what happened. Like say if the crane drops a load, maybe nobody got
Yeah.
hurt, but wouldn't, I mean, not necessarily, it wasn't really an injury, but we've got some damaged equipment, damaged material, productivity issues. So that would be another reason to look into it, wouldn't it? I would assume.
Yeah, it could be. I think, again, it's going to be facts and circumstances leading up to the event. I mean, just because an accident occurred doesn't necessarily mean that the employee was under the influence. That doesn't necessarily bring about the reasonable suspicion aspect of it. And that kind of goes back to, the blanket mandatory, after every incident drug testing policy. Again, like Dan said, is there a checklist? What did the witnesses say? Hey, did you guys have lunch with Frank before the incident? What how was he? What was he doing? Did he, follow up with it, document it? Exactly. You never know. So I mean, so there's definitely and Dan and I talked about this during our presentation. There's got to be a common sense approach to this and a reasonable approach to how you're going to go about doing the investigations and making these determinations. And and have some consistency with it. And like Dan said, follow, put together some type of a policy, document things, go through a checklist, and make sure that you're following the appropriate analysis before you're
As soon as you
jumping
tell
to
me who that
conclusion.
reasonable person is, I will go talk to them.
I'd like to meet them
Yeah,
as well too. So yeah.
So what would be your advice to employers generally when you get into something like this? Either
When we talk about developing a drug testing policy, we go through what is most important to the employer, right? Is it, hey, we want a zero tolerance policy? Are there safety sensitive positions where it's more important, I guess you could say, and critical that there is zero tolerance in those types of positions, right? What is their appetite for conducting testing for marijuana, perhaps under what circumstances? Maybe we do it in reasonable suspicion and post-incident testing, but not at pre-employment and not during random tests. There's a host of ways that you could potentially craft your policy and individualize it to your needs, right? And we talked a little bit about those considerations, right? Are we eliminating a large subset of perhaps really productive, well-performing employees with such a strict policy? Those are things that we talk to them about right from the get-go, right?
And even think about pre-employment, but yeah, it's tricky depending on the job. But like say you may not find an employee if you're going to do test everybody. Though the state of Michigan, I think, still does drug test everybody before they hire, don't they? I believe they still do that.
Within public service, the government,
Yeah, public service, yeah.
Yeah, perhaps. I'm not, I don't have that off the top of my head, but
yeah. And it's been a while since both you and I,
Yeah,
Sheila, have gone
like
through that process. So yeah, but I do recall going through that testifying,
Yeah, I did too.
back in 2000.
So we're kind of getting to the end of this. Have you got any final thoughts or anything that you didn't get to say and I talked too much or
Yeah, I mean, just, if I could just kind of, give you my little 2 cents on this from the OSHA perspective. Like I had said earlier during, when I was during the discussion, the intent of the injury and illness record keeping rule is to encourage employers to track and identify trends and patterns in their, injuries in their workplace for the purposes of identifying and expanding and addressing health and safety issues. If the drug testing policy is blanket and that does put a chilling effect on that, you're missing that valuable information that could identify potential gaps in your system. So, be aware of that, and, exercise some common sense when you're applying these rules. It's a challenge. I get it. I mean, and from a legal perspective, an employer's perspective, and a health and safety perspective, all these different things are kind of coming together, and it definitely creates a very complex situation here. But I don't want to, we don't want to lose that valuable information through the chilling effect of not encouraging employees to report because of the fact that they could possibly be scrutinized for potential drug and alcohol issue.
We already have employers that discourage people reporting accidents. I mean,
Exactly.
we've seen that, and that's not good. Dan, anything to add?
Yeah, I can just give kind of a quick summary for employers in Michigan, right? And this is really as it relates to marijuana, right? So workplace drug testing laws in Michigan, they do not restrict employers' right to test employees and applicants or candidates for marijuana, right? Let's set that stage. So zero tolerance policies are certainly enforceable, but there's a lot of considerations in whether you want to create such a strict policy, right? Or under what circumstances. Michigan employers, you are free to discipline employees or refuse to hire a candidate who has tested positive for marijuana, regardless of whether they have a medicinal card, right? So no employment protections for registered card holders. And despite that medicinal use law, you're not required to make any accommodations either for use of medical marijuana. So those are kind of the key things that we want to remember in Michigan with marijuana and employment laws. But like I said, all those considerations of whether you want to enforce a zero tolerance policy are something that you want to think about, right? A lot of employers are softening that zero tolerance approach, especially for jobs that are not safety sensitive, where safety is really not an essential function. There are some complicating factors here in recruiting the workforce, right? Finding high functioning and really good employees who use marijuana. Do you want to completely eliminate them from your job pool? That's something that is a question and an important one, right? So those are kind of, what is your risk tolerance is really what it comes down to. What is your risk tolerance as an employer? That's what you want to evaluate in the first instance when thinking about what type of drug test policy and what you really want to put together.
So common sense and reasonable and being reasonable. I mean, you can have a progressive discipline system, obviously. So,
Yeah. Yeah. And then the final thing there is we touched on this, but kind of going back to Tony's explanation on the OSHA's post-incident drug testing rule, the way to provide some additional protection for you as an employer is to conduct a reasonable suspicion analysis anytime there is an incident, right? We can't stress that enough. That way you're not just solely relying on a post-incident justification for doing a drug test. You may have to if there is no reasonable suspicion, certainly. But if you have reasonable suspicion, that in and of itself justifies a drug test.
So in place of a zero tolerance, at least have some reasonableness to the policy that you come up with. So all incidents are not the same.
Right.
Though we'd like it to be, but it's not reality. Well, our mission with the Michigan Safety Conference is to enhance workplace health and safety by sharing EHS best practices, provide education, and create a community of experts to help eliminate workplace injuries and fatalities. As we've discussed, navigating through the rules and regs is complicated, and obviously there's not one rule that fits every circumstance when it comes to substance abuse and drug testing while keeping a safe workplace. Thank you to Dan and Anthony from Conn, Maciel, Carey. They can be reached at Deacon or Casaletta at connmaciel.com. And I'd also like to mention their upcoming Midwest Workplace Safety OSHA, OSHA Labor and Employment Law Summit on Thursday, June 5th in Birmingham, Michigan. If you have any questions about this podcast, the Michigan Safety Conference, if you'd like to be a guest or sponsor one of our podcasts, information can be found on our website at MICH, M-I-C-H, safetyconference.org. Thank you for listening to Safety Spectrum. This is Sheila Ide.